I'm Gary Feldman.
I'm Tamsin Kaplan.
So we're Davis Malm. We're two of the lawyers in the employment group. Welcome to our presentation on some new developments in employment law.
I did want to talk about upcoming legislation. In particular, I wanted to focus on non-compete legislation. We do have a few more minutes. Many of you have probably seen the news that Governor Patrick has proposed a bill which would ban non-competition agreements in Massachusetts. In fact, there have been 3 bills pending for about 4 or 5 years that to some extent either ban or reduce the scope of legal non-competes in Massachusetts. Right now there are, Evie, is it 18? I think there are 18 states that have either made non-competes completely unenforceable or have proposed legislation to make non-competes completely unenforceable or have in some way reduced the scope of non-competes, the universe of non-competes that can be legally enforced in those states. So there appears to be a trend toward limiting non-competes. In Massachusetts, up until this time, at this time, non-competes are absolutely enforceable. The way the courts look at them is to weigh the interests of the company in protecting their legitimate business interests, their good faith, their goodwill, their relationships, their reputation, their confidential information, against the interests of the employee in pursuing a livelihood, in pursuing their chosen career. And they look at non-competes that way. And typically they'll be enforced if they're reasonable in duration, reasonable in scope, and don't unreasonably burden the employee while reasonably protecting the interests of the company. So that's the way they're enforced in Massachusetts. It's this balancing. There are certain exceptions in Massachusetts for physicians, for social workers, for nurses, and for people in the broadcast industry. I've never quite understood that one. Right. And for lawyers. Never lawyers. We always get the goodies because we write the laws.
I've never understood the people in the broadcast industry, how they got that in there. Good lobby.
Exactly. Just DJs can't have non-competes. Right. For example, so what's happening with this proposed legislation and how is it going to affect you? Right now, the governor's proposed legislation is being fast-tracked at the State House, and we expect that it will become law. There's been, over the years, all this work toward limiting or banning non-competes. The important thing to remember is that really the concepts, the principles that we've been talking about, that I've been talking about with my clients all these years, still apply, which is that you always want to protect your business in a way that is the most, with restrictive covenants that are as narrowly tailored as possible to protect your interests without overly burdening or limiting your employees. So non-competes, which say you cannot go out and work, say, in this industry or work with our direct competitors, are fairly broad. They're broad restrictions, and typically we've used them only for situations where we absolutely need them to protect our interests, because we have other tools for protecting our interests, such as confidentiality agreements. If you want to protect your business information, your client's information, your product information, your financial information, you can have a confidentiality or non-disclosure agreement. With salespeople, people who go out and interact with your clients, with your customers, you can have a non-solicitation agreement. They might go to a competitor, but they're not allowed to grab your clients, or they're not allowed to use your vendors. There are other ways, such as trade secret agreements, that you can protect your interests. You could have non-solicitations that prevent somebody, for example, from soliciting your employees and your contractors when they leave. So there's not going to be some kind of a lift out, and they're not going to raid your staff. So I encourage you to be thinking about your non-competes to the extent that you have them in place, and whether there's a more narrowly tailored way to protect exactly what it is you're trying to protect in that situation without having a broad across-the-board non-compete. And to the extent that you can do that, you're going to be in good shape, because this new non-compete legislation, while banning non-competes, does allow specifically for agreements not to solicit or hire away employees or independent contractors, agreements not to solicit or transact business with customers. It specifically still allows for non-disclosure agreements. It specifically still allows for non-competes in connection with the sale of a business for employees who own at least 10% of the company and receive some significant consideration as part of the purchase of the business. And it still protects and allows you to use no rehire provision. So if somebody leaves, they have no right to be rehired. They waive their right to be rehired. So I don't know if Gary has anything to add, but my advice at this point is to expect that at some time in the future, your broad non-competes may not be enforceable, and so we want to the extent possible, again, protect our interests with these other tools that we have. Depending on what exactly it is that we're trying to protect, we can use these other tools.
There is some strong opposition to the bill. I mean, it feels like now that the governor is behind it, there's a momentum, there's a groundswell, because there's been bills that have been introduced. There's several of them that have kicked around and gotten nowhere, and this is the first time that the governor has gotten behind it. But the EMCs of Massachusetts, Fidelity, a lot of the big employers have come out strongly against it. So we'll see. I think there's still an expectation that this time this will get through, and as the governor points to, and a lot of people in support of this legislation point to, California has for many years, as we all know, banned non-compete, and it has certainly not slowed the pace of innovation and worker mobility in California.
Well, and in fact, although Associated Industries and a lot of big companies are against it, this is part of an economic growth piece of legislation. So, I mean, it's the governor's view and the view of many that reducing non-competes actually fuels business and fuels the economy because it encourages innovation. You're not shutting people down.
Is there a distinction in the draft legislation which you pay for?
One of the bills that has been pending, the Brownsburger bill, had what's called garden leave, where if you continue to pay the person for that period, you can ask them to sit out or sit in their garden. This particular bill does not include that. I think that's a good point, and I suspect that may evolve as the bill goes through the committee process, that it may be that you can pay somebody to sit out.
California doesn't have that.
California, no non-competes.
California non-compete is a void as against public policy, any non-compete agreement. Not you protect trade secrets, protect confidential information, but there's no way, shape, or form that any non-compete agreement can be enforced that would be seen valid under California law. And my understanding is that the governor's bill is modeled on that. I haven't looked as closely as Tamsin has.
In my experience, oftentimes my clients are having their employees sign non-competes that are unnecessary. Really, non-competes are only necessary in my opinion, in very rare circumstances, because you can have the non-solicitations and the non-disclosures, and you can protect what it is you need to protect in most cases. So I would think carefully about those non-competes. And I've had clients who've come to me and they've had everybody, including their receptionist, sign a non-compete. It's just obviously overkill.
We've defended a case where another company tried to enforce a non-compete against a receptionist.
Okay.
Didn't get very far. It was a car industry case.
Always tough.
For you car dealers here.
Okay,
it wasn't you guys.
One question from one of our car dealer friends here.
If someone's already working for you, can you ask them to sign a non-solicitation agreement?
Yes, you can. The question is whether there's going to be adequate consideration. Our friend back there, yep. And so it's unclear in the law whether continued employment is adequate consideration for restricted covenants, so we always recommend that there be some kind of remuneration consideration at that time, like they get it when there's a bonus, or they get it for some kind of extra consideration.
There is a trend. There's no definitive, there's no authoritative, what we call authoritative opinion or decision on that issue about whether continued at-will employment is consideration for presenting and signing a non-compete.
So better
But the
safe
trend
than sorry.
is at the Superior Court, the trend is in federal courts and Superior Courts to find that it is. But in the exercise of, lawyers are usually cautious, so we would, we would always advise if you could find some way to give something extra, whether it's a bonus, raise, promotion, whatever it is, give something extra and tie it to that obligation, then you take away the issue.
Okay, please stay and ask us any individual questions you have. Enjoy the rest of your breakfast or start your day. Thank you so much for joining us.
Thanks
It was really a
everyone for
pleasure
coming.
having you.
Thank you.